Welcome to Ave Maria School of Law's video series on legal research. These videos will introduce you to the fundamental aspects of legal research. Today's video is a brief overview of the American legal system. Some of the material we are going to discuss here will be familiar to you. Nevertheless, a review of the legal system is imperative, as understanding the legal system is foundational to legal research. As you may recall, there are four main sources of the law. We have constitutions, statutes, court opinions, also known as cases, and administrative regulations. In other words, the law is all about rules, and the rules come from these four main sources. You should also recall that our legal system has two main systems of government. We have the federal system and the state system. Both systems have three branches of government: the legislative branch, which makes the laws, the executive branch, which enforces the laws, and the judicial branch, which evaluates the laws. Now, as I just mentioned, we have a federal system and a state system. Another way to think of this is jurisdiction. In this term, jurisdiction, you need to know. We have federal jurisdiction on one hand, and on the other hand, we have state jurisdiction. What this means is this: if you have a state law problem, then your problem is controlled by state law. For example, if you have a problem that strictly involves Florida law, your jurisdiction is Florida, and that means you need to research Florida materials. On the other hand, a problem involving a federal statute would be governed strictly by federal jurisdiction, and therefore you would need to research federal materials, not state materials. Knowing which jurisdiction is controlling is foundational to any research assignment because it narrows your research. Let's talk for a moment about the judicial branch or court system. The federal court system is comprised of three tiers. The bottom tier, or the lower level courts, are called the trial courts, and in the federal system these are known as the United States District Courts, and you see those listed near the bottom of the screen as trial courts. The second tier is the appellate courts, and these are known as the U.S. Court of Appeals. The top tier is the Court of Last Resort. This is the Supreme Court in the federal system. Now, keeping this tier system in mind is crucial because a hierarchy exists among the courts. That means that decisions from higher courts within a jurisdiction are binding on lower courts within that same jurisdiction. Most state courts systems follow a very similar structure. Every time you do research, you must consider two things: the type of authority you are reviewing and the weight of that authority. And in our system, we have two types of authority. We have primary authority and secondary authority. Primary authority is the law. These are the legal rules, and these come from constitutions, statutes, case opinions, and regulations. Now, the second type of authority is secondary authority. Secondary authority is never the law. It is never the law. Rather, it provides commentary on the law. An example of secondary authority is a law review article. Now that you have a basic understanding of the two types of authority we have, you will next need to understand the weight of each authority. And there are two types of weight. Weight is either mandatory, and that means that it is binding on the court, or the weight is persuasive, which means a court can accept it or reject it. In other words, it's non-binding. We will now discuss the weight of primary and secondary authority. And I will start with secondary authority. Secondary authority is never mandatory. It is always persuasive, and that's simply because it is not the law. Now turning to primary law. It is sometimes mandatory and sometimes persuasive. And for the next minute, I will discuss how to determine whether primary authority is mandatory or persuasive. And the key here is jurisdiction. That's why we discussed jurisdiction a few slides ago. For example, if we are dealing with a Florida issue, the Florida Constitution, statutes, cases, and regulations are mandatory for that Florida issue. But if a Florida court is considering a Florida issue and consults a Georgia opinion, that Georgia opinion is from a different jurisdiction. Accordingly, that Georgia opinion is non-binding on the Florida court, meaning the Florida court can choose to follow it or it can reject it. So decisions from courts in one jurisdiction are persuasive authority for courts within another jurisdiction. Another thing to keep in mind is the tier system or hierarchy that exists in the court system. Decisions from higher courts within the same jurisdiction are binding authority for lower courts within that same jurisdiction. Let me give you an example. Decisions from the Florida Supreme Court are binding on the Florida Courts of Appeals and the Florida trial courts. However, what if a court considers an opinion from a lower court within the same jurisdiction? In that situation, the lower court opinion is merely persuasive on the higher court. So let's say the Florida Court of Appeals issues a decision. That decision is binding on the Florida trial courts because the trial courts are lower than the Court of Appeals. But it is not binding on the Supreme Court because the Florida Supreme Court is a higher court than the Florida Court of Appeals. So when doing research, you must always keep in mind the type of authority you are using and the weight that that authority carries. Thank you for listening, and remember to take the quiz on Blackboard.